Hey Richard, great to see you today. So today we're talking about changes that will shortly come into force under the DMCC Act. That's of course the Digital Markets Competition and Consumers Act. Now there's a lot in the Act. There's obviously the new UK digital regulatory regime for the largest tech firms with strategic market status, the so-called SMS firms. There are also some significant competition law reforms. But the area we're going to focus on today, another equally important aspect of the DMCC Act, consumer law reforms. Would you like to start by just giving an overview of what those consumer law reforms are?
Yes, sure. I sometimes feel that the consumer bit gets a little bit overlooked in the discussions about this legislation because everyone's fascinated by the digital markets stuff. But let's not forget the consumer law bit of the Act is the largest part of the Act. And it does two things. It amends and updates the consumer protection law to some extent, and so there are new provisions on top of what we've already got on things like fake reviews, for example, that firms may be responsible for fake reviews on their websites, provisions on drip pricing. Which of us has not had to deal with drip pricing when we're quoted a price and then you go to the checkout and it's twice as much or more than you had originally anticipated? There's the phenomenon of subscription contracts where you find that you've signed up to something and may not be terribly easy to get out of it. So some quite important substantive law. But then separately from that, there's the enforcement regime. I think that's really the most noticeable feature of the legislation.
Yes, and I mean CMA already enforce consumer law, of course, and we've seen some high-profile examples of CMA consumer cases, and Oasis tickets, a very recent example. But is it fair to say that the kind of CMA consumer powers, particularly new powers to impose fines, are a real sort of game changer for companies in terms of consumer law compliance?
Well, I think it's an absolutely incredibly important moment in time. I have to say, personally, it's something I have hoped for a very, very long time, because let's suppose you are a competition and consumer authority, and your concern is whether markets are working well and are consumers getting the benefit from markets that they ought to get. Well, we hear complaints of a particular market. Maybe there's a cartel there. Maybe there's an abuse of dominance. But actually, it's much more likely that consumers are being affected by misleading advertisements or misleading information or unfair contract terms or whatever. I mean, these are the kind of things that can affect hundreds of thousands, if not millions, of consumers. And then you find this extraordinary asymmetry where if there's a competition law infringement, the authority can proceed under its own steam normally, can impose fines that may be up to 10% of a company's worldwide turnover. And then over here, in most jurisdictions, there are some consumer provisions. And what can the authority do? Go to court and basically ask for a declaration or for an injunction to stop this kind of behaviour, but nothing more than that. And I do think it's a very strange asymmetry. And what this legislation will do for the first time is to give the CMA the same kind of powers to enforce consumer law that it has in relation to competition law. And I think in principle that is right.
And so for companies, that will really sort of push consumer law compliance up the kind of value chain in terms of the concerns that boards are worried about in terms of compliance, and I guess needing to put more resource into that area potentially.
Well, it depends on what company you are. I mean, there are plenty of companies in this world that produce and sell upstream products that are a million miles away from consumers, so they wouldn't have a concern about this kind of stuff. But if you are consumer facing, selling goods and services to the consumer, then I think this is massively important, yes.
Okay, and CMA, obviously ahead of the DMCC Act coming into force, has been consulting on various new and revised draft guidance. And it's quite interesting in terms of the guidance on settlement discounts, in terms of how they're sort of viewing the comparative seriousness of consumer law infringements and competition law infringements, isn't it?
Well, yes. I mean, there is this idea that you're under investigation, competition law at the moment, maybe consumer law in the future, and you decide to settle the case. Now, this is hugely helpful for the authority, because obviously it means they can get a case over and done with much more quickly than would otherwise be the case. Also, let's face it, very often beneficial for the company as well, because running these cases, defending these cases is time-consuming, it uses up lots of resources, it's expensive, etc. So both sides can derive benefits from settlement, but then how much should you incentivize people to settle? And certainly the CMA's view is that when it comes to hardcore cartels, you are doing something very naughty indeed. So you've still got to pay a pretty hefty fine. And so the settlement discount there is relatively low for non-cartel cases in competition law, and for consumer cases, they are proposing higher settlement discounts. So there is a certain asymmetry there. But I think what this is about really is enforcing this law effectively, expeditiously, getting cases over and done with, because that ultimately raises awareness, hopefully has a deterrent effect, and I think it can help everybody to settle cases rather than to fight them all the way through the courts.
Okay, and just to finish on a timing point, so in terms of implementation of the DMC Act, the new digital regulatory regime for the SMS firms and the competition law reforms are expected to come into force start of next year. The consumer law reforms coming slightly after that. Can you see some logic behind that sort of stage timing?
Well, yeah, yes, I can see the logic there. I mean, on the DMU, Digital Markets Unit, let's face it, there's been a shadow DMU in existence for a long time. Their work is up and running, and Competition Act cases have already been closed and migrated to the DMCCA, and once that comes into effect, they will be ready to go with cases that are, as it were, 3/4 of the way there. What we're talking about here with consumer law is completely new. This is kind of revolutionary, maybe going a little bit far, but it's very, very new. So I don't find anything surprising in the idea that it would come into force later. I mean, I think the current planning is, for most of it, April 2025. I think for the subscription contracts, which is completely new law, I think that's 2026.
Thank you, Richard. Very interesting.
Okay.